Good afternoon, everybody. Welcome to Sinister. It is Monday, March 16th. Tomorrow's St. Patrick's Day, so otherwise I probably wouldn't know the date today. But anyway, I'm going to be talking about the amendment that Karen Reed has made to her complaint against the House defendants and Proctor and Buckenik. I can never remember his real name now. Buckenik. So yeah. But what about Kelsey Fitzsimmons, huh? I mean, isn't that exciting? I'm so happy for her. It's past time for her to get her baby back in her life and try to move on from what Justin and his family has done to her. I mean, Jesus, I don't know. I'm scared for her though, because I know these people are not gonna let up on her. I mean, his mom, it's like an Adelson situation, where the grandmother wants to raise the baby as her own. I mean, what kind of sick shit is that? Let's keep things in perspective here, okay, Lisa? I mean, I'm not sure your son wants to be a single father as much as you want him to be a single father. And I'm almost certain that's why he's living at home. He probably couldn't move out even if he wanted to, because you wouldn't let him. I mean, all your kids are adults and they all still live at home. That says a lot. That says a lot. And your kids are troubled. They're very troubled from what I've read. So, I mean, yeah, I don't know. I think that when you get that many kids in one family that are troubled, there's got to be a common denominator. And I think the common denominator in the Alain family is Lisa Alain, Mom Alain. And yeah, I feel for Kelsey because she has to deal with this lady for the next, I don't know how many years. I don't know how old Lisa Alain is. She doesn't look very old. So I think she's probably younger than me. So she's got another 30 years, I mean, it is what it is, but yeah. So, and Justin is on administrative leave. Of course, it's paid administrative leave, of course, but it looks like they're going to be looking into some of the allegations against him, which they should. I don't know what he was thinking coming after her the way he did and treating her the way he did, knowing that she knows all these things about him, knowing that she's got all this dirt on him, and he's just going to keep pushing her and pushing her and pushing her, backing her into a corner. What does he think's going to happen? She tried to play clean. She tried to play nice for as long as she could. But Lisa got her little hands in the mix, and look what it cost her son. Because you can only play nice for so long, and if somebody's just backing you into a corner like they were, you've got to come out fighting. You've got to. Your son is at stake. And she's coming up on a year now since she's seen her son and since her son has seen her or heard her. And she's just missed so many milestones that you just can't get back. I mean, yeah, it's heartbreaking. But now she gets to move into her own apartment. She gets to be back in his life. I mean, yeah, it warms my heart to hear that things are finally starting to look up for her. Um, the whole JFK and J. Brill thing in front of the courthouse, though, not cool. It's not cool. You're supposed to be there covering the hearing, and I don't even think J. Brill went inside the courthouse. He stayed outside and harassed Aiden the whole time. Aiden went in, but J. Brill, nope. I think he's probably got something against courthouses, if you ask me. Yeah, my hair is looking a little has a little bit to be desired. Or, I mean, it's what the fuck is going on here? I mean, it is what it is. I've been helping my friend move, and all weekend, and then today I promised her that while she was at work, I would go to her house and try to fix her, basically take it apart and reassemble her TikTok makeup vanity that cost her over $1,000, and it's a piece of shit. And I'm telling you, people that are big TikTokers out there and like to spend money at the TikTok shop, do not buy the makeup vanity with the lighted mirror and everything. It is a piece of shit. She's never moved since she got it. And I think they count on that because it is not movable. That thing fucking fell apart. It just like crumbled in our hands when we tried to move it. It was insane. It's got those, those little disc screws that have the peg in the other one piece, and then it's got the disc screw in the other piece, and you turn that big disc screw and it pulls the peg into the hole and it connects the two pieces. That's how the whole thing is put together. No screws, just those little pegs. And it's particle board, of course, so, it fucking breaks like that. And it's just insane. I cannot believe that cost her $1,000. And so I told her I would try and come. I think they put it together backwards too, which didn't help because the pegs weren't lining up. So I went over there today and sweated like a frickin' whore in church. It's really warm here in California, and which means we're probably going to have a really hot summer. Dreading in that, but yeah, I went over there and I worked on it for like 3 hours. I basically took it apart and reassembled it, switched it to opposite sides because, like I said, I think they had it backwards, which they did because the pegs matched up at that point. But then we decided to use little brackets on the inside corners of some of the bigger components because there's no way to move it without it falling apart. And we still need to get it in our house because we were going to glue part of it. So we left it in the garage. And I hate screwing brackets in. Those are the biggest fucking pains. And it took me 1 hour to basically get one bracket in. I was losing my shit. And I was cussing and screaming and yelling. And her neighbors are probably going to give her an earful when she gets home. But finally, I did what I could, and then I decided, you know what, I need to stop before I get so pissed off that I just fucking destroy this whole thing, because it's ridiculous. I feel bad for her, and that's why I'm trying to help her fix it, because she's out $1,000. But don't order it. They're ripping you off, people. I mean, it's like the typical IKEA furniture. It's good for when you're stationary, but it's not good for any moves because once you start moving, it starts falling, getting rickety and weak and yeah. And that is the perfect example of something that is not made to move. So if you're planning on buying it, buy it before you move and then have it brought in. I wouldn't even say have it assembled for you, because these fuckers didn't know what the hell they were doing. And so they tried to glue it, and then in the back you can see all this glue dripping down that's dried, because, it was dried by the time they delivered it to her, the glue was. But luckily you can't see it, but it's just like the quality of the product and the quality of the work leaves a bit to be desired, if I'm being honest. I mean, what the actual fuck? And they're making $1,200 a pop on each one. No one's the wiser. So I'm just here to tell you, do not buy it. Do not waste your money. I mean, I don't know why particle board is so expensive when it's so cheap. Or chintzy. I guess cheap's not the word I'm looking for, because it's not cheap. It's very expensive. But it's fucking... it's shitty wood. I don't like it. I mean, and that's what they make everything out of now. Because if you use real wood, you're going to pay out the ass for it. So there's that. Anyway, yeah, I don't know how we got on this. Oh, because my hair is trash today. Because I just got home and I decided I have the house to myself for a minute. And so I'm going to do my video now. I was going to do it 2 nights ago, and things got away from me. Time got away from me. I was going to do it last night, and the family decided to be in the house most of the evening. It's like, you guys are never in the house. And now I want to do a live or a recording, and you guys feel the need to be in the house, which means the dogs are in the house, which means the dogs are going crazy. And then I was up all night with the puppy, because I don't know, she's got this thing. We thought maybe she was getting into something, but last night my husband got up to go to bed, and she was sleeping sound asleep right next to me, and she got up and followed him to bed. So she didn't get into anything in between the living room and the bedroom. And when I got in the bedroom, she was coming unhinged. She acts like she's tweaking. That's all. That's the only word I can think of that describes how she gets. Tweaking. And so I knew she wasn't going to go to sleep, so I got up with her and was up with her most of the night. She's crashed out now, but we thought maybe she had, because this isn't the first time it's happened. But there's no way she had a chance to get into anything last night, and she was crashed out right before she went to bed. So I'm thinking maybe she's got some kind of condition, and it's not something that she's getting into. So I don't know. If anybody's got any suggestions, I'm here to. I'll listen, because I don't want to pay thousands of dollars in vet bills just to have them say, "Oh, she just, hyperactive," or something like that, but this is beyond hyperactivity. I mean, she's tweaking, literally tweaking. I mean, she's all, it's just her head movement and her, I don't know, her eyes and the way yeah, it's insane. So there's that. So, so I've had quite an adventurous few days off on my stretch off. So I'm almost ready to go back to work, if I'm being honest, because, yeah, I mean, my body is sore from helping my friend move. I helped her move like 6 years ago, and I was sore then, but it was a whole different kind of sore. This is like old body sore, like an old lady's body is sore. You know what I mean? It's not like, I mean, I work out every day. I cross train, I cycle, I walk my dogs, and this was a sore. I mean, my back was sore, and then I think I did something to my hip, but I hurt my hip joint, actually cycling. So I had to do, my workout consisted of 2 minutes on, 2 minutes off of standing and sprinting on the bike. And I did something to my hip. I thought it was just muscle soreness. And then by 2 to 3 days later, I couldn't even put any weight on my right leg. That's how bad it hurt. I thought I was going to die. And I have a really high pain tolerance. So, yeah, I'm feeling stiff still, but I think that pain is starting to go away. But yeah, it sucks getting old. I'm here to tell you. So, let me see if I can find... Oh, shit. Did I lose it? Okay, no, I got it. So let's get into this document because it's kind of long, and I'm going to take my picture off and just put my avatar on because, yeah, I don't like these glasses, how they look on me, so there's that. But, can we make it bigger? Okay. So, it says United States District Court, District of Massachusetts, Karen Reed plaintiff v. Michael Proctor in his personal capacity, Sergeant Yuri Buckenik in his personal capacity, Lieutenant Brian Tully in his personal capacity, Town of Canton, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins are the defendants. Amended complaint 1, or I, introduction. 1. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct... Come on, get out of here. Gross misconduct of the Massachusetts State Police, MSP, and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29, 2022. 2. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton, quote-unquote, house, in an altercation during a late-night house party. With other defendants, parentheses, collectively the quote-unquote house defendants, parentheses, after a night of heavy drinking. The house defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the house defendants conducted a Google search for information about, quote, Haas Long to die in the cold, end quote. Moved Mr. O'Keefe's body outside and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts' lawn until Karen Reed found him later in the morning. 3. From the beginning, investigators from the MSP allowed the house defendants to direct the investigation away from themselves and towards Miss Reed. The house defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for the MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House Defendant Brian Albert was the longtime Boston Police Department officer, and House Defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. 4. Adhering to the unwritten rule of, quote-unquote, protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of the head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a three-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. 5. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures, propelled by the House defendants' false statements, including that Mr. O'Keefe, quote-unquote, never went into the house. Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any quote-unquote shit for this because he's, Brian Albert, a Boston cop, and that Proctor was quote-unquote determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed had quote-unquote zero chance of skating. She's fucked. This pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house, let alone investigated inside the house. Number 6. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts. German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Number 7. Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones, except that which belonged to Jennifer McCabe, who turned her phone over only after making settings changes to the phone on February 2nd, 2022. Yeah, because she actually deleted a bunch of messages off her phone too before she voluntarily handed it over, right? I mean, that's what she makes a point of telling everybody. And even if there were knuckles bruised and battered and cut up, they would just say that they fell on them when they were slipped on the snow or ice and tried to save their drink, like Colin Albert said when they asked him about his knuckles after this incident. You can't make this shit up. It's insane. Okay. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Miss Reed, as implicitly directed by the House defendants through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Yeah, if they ever brought these people up on murder charges, it would be it would just be a circumstantial case. There's no physical evidence anymore because they never did collect any, because they never did an investigation. Number 8, Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a quote-unquote thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Miss Reed. Proctor then went so far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene, on Mr. O'Keefe's clothes, and on Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed is a quote-unquote whack job cunt, retarded, a nutbag, and a babe with no ass. Proctor further ridiculed and derided Miss Reed. Is that right? Derided? Miss Reed for her serious medical condition, stating that her quote-unquote balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Miss Reed's phone, he was looking for naked pictures of Miss Reed. Disappointed, he reported that there were quote-unquote no nudes so far. In an unfiltered utterance, Proctor revealed his true mindset. Quote-unquote, hopefully she kills herself. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Tully and Buckenik, responded with a quote-unquote thumbs-up emoji to a text calling Miss Reed quote-unquote retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts, and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claims against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. On June 18, 2025, after a 2-month trial, jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed. Yeah, they haven't even given her phones back. I think she finally got her car back, but they're fighting her on her phones. Just a second, I'm going to get a drink. If that didn't mute, I'm sorry, because last time I was live, my microphone wasn't muting. I was having to mute through StreamYard. I've never had to do that before. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, quote, The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve these regards, end quote. You know what I'm hoping for? I'm hoping that, I can't remember his name now. Reich? Is it Reich? Reich? The man, the guy, the ex-U.S. attorney that's running for Norfolk County DA. I'm waiting for him to become DA because he's going to reopen the O'Keefe case. I can guarantee it. Because he uses the House defendant's pictures in his campaign video. When he's talking about corruption and how things need to change in Norfolk County. So I hope, and you guys better get out there and vote so that he gets elected, because he needs to hold these people accountable for all the egregious shit they've done over the years. Just saying. In an interview with the Boston Herald, Noble acknowledged this. Noble acknowledged the systemic nature of MSP's conduct in Miss Reed's case. Quote, I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor, end quote. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. On March 19th, 2020, transferring them to a different unit or whatever, that's not solving the problem. That's just going to make somebody else in a different area a victim. They're still going to victimize people. On March 19, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor, quote-unquote, guilty of a Class A violation, which included, quote, that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute, end quote. Miss Reed's life was not merely turned upside down by the MSPs and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional stress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks at minimum to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Roman numeral 2. Parties. Plaintiff Karen Reed is an individual residing in North Dighton, Massachusetts. Defendant Michael Proctor is a former MSP trooper residing in Canton, Massachusetts. He is being sued in his personal capacity. Okay, this just lists all the defendants. I don't feel like going over that. Roman numeral, because it's 54 pages, I'm going to try and get through it all. Roman numeral 3, but I'm going to cut corners where I can. Sorry. Roman numeral 3, jurisdiction. This court has subject matter jurisdiction over this case pursuant to 28 U.S.C., and then it says the statute. This case was removed to this court by certain defendants pursuant to, and it says the statute. Roman numeral 4. Facts common to all counts. Mr. O'Keefe's death. Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28, 2022, Mr. O'Keefe and Miss Reed went out for the night. They first went to C.F. McCarthy's in Canton, and where they had several drinks. They then went to the Waterfall Bar in Canton. There they met up with a group of acquaintances, including Brian Albert, his wife Nicole Albert, Brian's brother Chris Albert, and his wife Julie, Jennifer McCabe, Nicole's sister, and Brian's sister-in-law, her husband Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road. the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Higgins resided in Canton for many years through January 2022 and was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor as well as with Brian Higgins. Higgins had been on a trip with both Brian and Kevin Albert in the days preceding January 29, 2022. Yeah, they went to New York for a cop who was killed, his funeral. But yet they didn't go to John O'Keefe's funeral. They didn't know the cop in New York, so they can't use the fact that they didn't know John O'Keefe for not going to John O'Keefe's. And by the way, it has since been found out that John O'Keefe and Brian Higgins were pretty good friends. They texted each other quite a bit. So there's that. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Miss Reed and Mr. O'Keefe had never been to the house before January 29th. They arrived in front of the Alberts' home from around 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late-night party. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door/garage door area of the house and entered one of the two doors. According to O'Keefe's Apple Health data, his final steps covered just enough distance to get from the foot of the driveway and into the house or the garage. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. Excuse me. At some point after entering the house/garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Alberts' German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating contusive wound on the back of his head. It's in the back of his head. It's not on. Mr. O'Keefe's head wound was caused by falling backward and striking a rigid surface. The Alberts' garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. The frozen grass, I can't remember the accident reconstructionist from Canton PD. Oh my God, I can't remember his name. But yeah. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and Higgins, house defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired that Mr. O'Keefe, quote-unquote, never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passers-by. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold. Mr. O'Keefe was either dead when the house defendants left him on the Alberts' lawn, or he died shortly after. I thought he still had a pulse when they found him. Didn't they say that? And they pronounced him at the hospital? I'm pretty sure they said that. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some quote-unquote administrative work, but then changed his story, subsequently stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm, even though he could have done that earlier in the evening when he was at the station to drop off Kevin Albert. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls. Yeah, they were butt dials. And then when confronted with their existence by a quote-unquote separate law enforcement agent, a non-MSP and non-CPD law enforcement agency, at a quote-unquote separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls, answers, and hang-ups were just quote-unquote butt dials. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m., quote, "house long to die in cold," end quote, misspelling the first word. Miss Reed searches for Mr. O'Keefe. I'm not sure what the amendment is so far, so I'm sure we're not there yet. They're just giving the background, I guess, which everybody's heard a million times. Miss Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned House Defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. Ms. McCabe insisted that Miss Reed drive to McCabe's house rather than to 34 Fairview, which Miss Reed did. At the exact same minute Miss Reed left Mr. O'Keefe's home, 5:07 a.m., McCabe made a 38-second phone call to her sister Nicole Albert at 34 Fairview. Nicole Albert said she was asleep until after 6 a.m., and Jennifer McCabe, when confronted with the call artifact at trial, claimed not to have any knowledge of the call. Miss Reed and Miss McCabe were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, McCabe directed them to go back to Mr. O'Keefe's house, where Miss Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. As they approached the house, with Roberts driving, Miss Reed saw Mr. O'Keefe almost immediately. She screamed for Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was, quote-unquote, discovered in front of the Alberts' house near a flagpole and fire hydrant on the left side of the Alberts' property as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Roberts joined Miss Reed with administering CPR, McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that, quote-unquote, "there's a man passed out in the snow." I can't do an imitation. I can't do Boston. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. Yeah, the only way you wouldn't be concerned about your family possibly being hurt or killed is if you knew that what happened to John O'Keefe to begin with. Otherwise, you would run into your house or into their house. You would think that they were hurt too. I mean, John O'Keefe was in their front lawn. The CPT were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking CPD officer on the scene, Sergeant Michael Lank, opined on a telephone call to MSP Homicide, MSP Homicide, captured on dashcam audio, that Mr. O'Keefe looked like he had been in a fight. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn or in the roadway that morning, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body, no one from the Alberts house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabe's. Pursuant to their plan, the Alberts and the McCabe's told Sergeant Lank that Mr. O'Keefe had never entered the Alberts' house the night before. The Alberts and McCabe's statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts' dog, and suffered a fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Lank nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabe's. After Sergeant Lank returned to the CPD 3 hours after the discovery of Mr. O'Keefe's body and more than 2 hours after being interviewed at the Alberts' home that morning, Jennifer McCabe called Sergeant Lank to report that she, quote-unquote, recalled additional information. Except for this one call to Sergeant Lank, McCabe deleted from her phone evidence of all other phone calls she made and received from January 28th to just before 9 a.m. on January 29th. As part of the plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Miss Reed told her twice that morning, quote-unquote, I hope I didn't hit him. More than a year later, at a separate proceeding, McCabe changed her story on this topic yet again in furtherance of the House defendants' plan. McCabe then falsely reported that Miss Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buckenik was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Buckenik and Proctor. In their roles, Buckenik and Tully both knew at all times the exact extent of Proctor's misconduct in investigating Mr. O'Keefe's death, as described below. I think that Tully is probably the worst of all of these guys because he is at the heart, he's at the meat of everything. He's involved in every aspect of Karen Reed's case, every aspect of Turtle Boy's case. He was involved with Lindsay, directly involved with Lindsay. He's got his tentacles in everything. I mean, he's actually involved in absolutely everything that has gone on, so I think he's the dirtiest. Yeah. So, that's just my opinion. But anyway. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister Courtney was also a close friend of Julie and lived walking distance to the Alberts' home at 34 Fairview Road. In fact, Proctor's own mother referred to the Alberts as the Proctor second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Buckenik and Tully, in an effort to ensure that the House defendants were protected and that Miss Reed's right to a fair investigation and trial were undermined. Proctor, Buckenik, Tully, and the MSP never searched for DNA evidence inside the house, never looked for rigid surfaces that could have caused the gash on the back of Mr. O'Keefe's head, and never inspected the house defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the house defendants' cell phones with the exception of Jennifer McCabe. This allowed potential... It's funny that the one cell phone they searched is the one that had the stupid Google search in it. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor's, Buckenik's, and Tully's interviews of the House defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home in the case of Brian Higgins, their lawyer's office in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it. Specifically, Jennifer McCabe became the point person of the House defendants in providing their false narrative to investigators and continued to serve that role for years. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. McCabe was wildly active on her phone in the immediate aftermath of the house altercation that killed Mr. O'Keefe. Her cellular data reveals that she arrived back at her home at 12 Country Lane at 2:12:38 a.m. on January 29th. Her phone was unlocked between 2:23:41 a.m. and 2:31:07 a.m. Text messages were sent between 2:25:11 a.m. and 2:25:26 a.m. Two screenshots were deleted at 2:26:37 a.m. Her Apple Health recorded steps throughout the night after she arrived home at 2:14:03 a.m., 2:15:33 a.m., 2:16:34 a.m., 2:17:38 a.m., 2:18:32 a.m. Okay, I'm not going to go through all those. 18 calls were deleted between 5:33:47 a.m. and 8:15 a.m. And an outgoing call to Nicole Albert at 5:07:21 a.m. The last cellular artifact is particularly revealing because McCabe's call to her sister occurred 1 hour before John O'Keefe's body was discovered, mere moments after a 43-second call at 5:05:14 a.m., during which Miss Reed and McCabe agreed to go searching for O'Keefe. Parentheses. Ring video from One Meadows shows Reed leaving the property at exactly 5:07 a.m. McCabe's coordination continued on February 1 when she worked with another witness, Carrie Roberts, to draft a timeline in order to align their stories regarding what had occurred on January 29th. They did this in preparation for Roberts' interview with MSP, which occurred at the McCabe's residence, despite MSP's protocol to separate witnesses when interviewed. While MSP interviewed Roberts, McCabe simultaneously texted her husband, Matthew McCabe, Nicole Albert, and Brian Albert, saying, quote, "She's telling them everything," end quote. Quote, "all the stuff," end quote. Nicole Albert responded, quote unquote, "good, and call us after." 2 months later, after being prodded and influenced by McCabe and the other House defendants, Roberts changed part of her story to better fit with Jennifer McCabe's own false statements. Specifically, Roberts testified falsely in a state grand jury proceeding on April 26 that she heard Miss Reed ask Miss McCabe to Google quote unquote hypothermia. She had not made this claim in any of the at least 3 interviews she gave to MSP investigators in the days after Mr. O'Keefe's death, in part because it never happened. Carrie's new and false story to the state grand jury aligned exactly with McCabe's testimony that Miss Reed asked her to Google hypothermia. Roberts even adopted McCabe's false claim that Miss Reed had supposedly asked the question while praying in a CPD cruiser outside of 34 Fairview Road. Later, Roberts conceded that she never heard Miss Reed ask McCabe to Google anything. She admitted this a year later at a separate proceeding on April 19, 2023, conducted by a different law enforcement authority, not Proctor and MSP, and again during Reed's criminal retrial in 2025. The House defendants deleted many of their texts among themselves and others in the aftermath of Mr. O'Keefe's death. The texts captured before deletion or recovered later also reveal some of the House defendants' planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister Nicole Albert that Carrie Roberts, who was present when Mr. O'Keefe's body was found, quote-unquote, talked to cops and kept it simple. Of course, there would be no reason to report back to other House defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Buckenik, and the MSP never sought these communications. Rather, they were obtained by Miss Reed's defense attorneys, repeated motions to compel access to data on Jennifer McCabe's iPhone. Just 1 second, I need to take a drink. Later, in other group texts with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, quote, ask Chris to ask some questions. Tell them the guy never went in the house, end quote. As an endorsement of the plan, Brian Albert responded, quote, exactly. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. That's where the FBI comes in. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in O'Keefe's death, another quote-unquote separate law enforcement agency began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining some of the House defendants' phones, taking statements from the House defendants, and conducting a quote-unquote separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency's investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Proctor and Buckenik initially interviewed the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. However, Jennifer McCabe's cell phone location data shows that she was at 34 Fairview all morning, leaving at 11:15 a.m. just in time to meet Proctor at 12 Country Lane at 11:30. According to Proctor, he was at CPD just a mile from 34 Fairview before proceeding to the McCabe's home for their scheduled interview. At that point, Proctor had still not inspected 34 Fairview and had not interviewed either the McCabes or the Alberts. He could have done both simply by driving a mile to 34 Fairview, where both the McCabes and the Alberts were minutes earlier, rather than drive across town minutes later in a snowstorm. He did this intentionally to avoid 34 Fairview, where he would have been required to inspect the house and property and make reportable observations. He also wanted to make the McCabes and Alberts more comfortable for their interviews. Buckenik and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd. 2022. Did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged. And did not interview Caitlin Albert and Brian Albert Jr. until September 15th, 2023, nearly 2 years later. Before both interviews, the McCabe's and Alberts continued to coordinate their stories as evidenced in group texts. Proctor, Buckenik, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buckenik interviewed Higgins on February 3rd at Higgins' attorney's home in Sharon, Massachusetts, Higgins presented the troopers with a select self-curated texts between himself and Miss Reed. They learned that Higgins and Miss Reed had been exchanging flirtatious texts, and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Rather than pursuing Higgins as a possible suspect, Proctor, Buckenik, and Tully refused to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and the parking lot of CPD at 1:30 a.m. on January 29th. I would say, and after seeing the video at the waterfall where he was calling John out, too. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buckenik, Tully, and MSP not investigate what Higgins was doing or what was in the bag he was carrying in the video, but they went so far as to hide this video from Miss Reed and her criminal defense attorneys for years. Miss Reed's defense did not receive these videos until after she stood trial for the first time. And even after the quote-unquote separate law enforcement agency's investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone, or even a simple call log from his cellular provider. This concerted inaction by MSP, Proctor, Buckenik, and Tully directly benefited the House defendants, especially Higgins and Brian Albert, who proceeded to dispose of and destroy their phones just as the criminal court ordered them preserved in response to a motion by Reed's criminal defense team. Specifically, on September 15, 2022, Ms. Reed's defense attorneys filed a motion requesting that the court order Brian Alberts and Higgins to preserve the contents of their phone. A Superior Court judge held a hearing on that motion on September 22nd and announced in open court that the defendants were required to preserve their phones, signing a preservation letter to that effect on September 23rd. Higgins was served with a copy of the court's order on September 30th. Why would it take 7 days to serve him? That's ridiculous. That's not okay. He later testified that he changed phones and mobile carriers on September 29th. Later, in October 2022, Higgins then destroyed his old phone, which was subject to the court's preservation letter. In fact, Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and card in 2 separate dumpsters before driving back home. Brian Albert received a copy of the preservation letter sometime between September 23rd and 24th. He originally testified that he threw away his phone in the quote-unquote third week of September 2022, but then later claimed that he did so on September 22, 1 day before being notified of the court's order, and the same day Miss Reed's defense attorneys argued in open court that the phones should be preserved. Was he in court that day, I wonder? If he was, that's even more suspicious. Higgins and Albert's destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor's, Buckenik's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records or simply interviewing Higgins and Albert to inquire about the nature of their late-night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1 and 2, and at least 67 times between February 1 and September 6, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was quote unquote not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced above, when his sister informed him that Julie Albert had been, quote-unquote, so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked, quote-unquote, why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that, quote, it was fine, just a quick convo, end quote. And then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He protected them and treated them like the family friends that they were. At one point, leading up to some of the interviews, Jennifer McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert again, through Courtney, Nicole Albert responded, quote, we'll get more info tomorrow. Don't want to text about it, end quote. House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Jennifer McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Sergeant Lank's house. However, while they did not text about this meeting, McCabe's cell phone location data, obtained later by Miss Reed's defense, reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. Again, the cellular evidence and the deception by McCabe was never investigated further by the MSP, despite the fact that they had McCabe's full phone extraction since February 2022. The McCabes, Alberts, and Higgins all told similar false stories to investigators in their interviews, and Proctor, Buckenik, and Tully accepted the coordinated statements without making efforts to corroborate their stories. For example, Higgins testified before the state grand jury on April 28th that he parked his Jeep Wrangler in front of 34 Fairview Road for the duration of his stay on January 29th. However, none of the House defendants or the percipient witnesses who parked briefly out front around 12:30 a.m., Ryan Nagel, Heather Maxson, and Ricky Tuano, ever testified about seeing any other vehicle parked there other than Miss Reed's Lexus. Matthew McCabe claims to have seen quote-unquote V-shaped tire tracks in the snow, another observation not corroborated by any other witnesses. Further, Brian and Nicole Albert initially told Sergeant Lank of CPD that their daughter, Caitlin Albert, left the house that night around 12:15 a.m. when she was picked up by her boyfriend. However, when Caitlin Albert and Brian Albert Jr. were interviewed in August of 2023, they both testified that Caitlin was the last person to leave 34 Fairview that night at approximately 1:45 a.m. And I think, to be honest with you, I think that's who took Chloe the dog. I think her fiance, when he picked her up, took the dog. Just 1 second. And the reason why I think that they took the dog is because the dog, no one recalls hearing the dog barking the next day. And with all that activity at their house, that dog would have been losing her shit. Just my opinion. Brian and Nicole Albert clearly made efforts to exclude placing their eldest daughter in the house when Mr. O'Keefe was there. Neither Proctor, Buckenik, Tully, Lank, MSP, or CPD ever further investigated this 90-minute discrepancy regarding the presence of a key witness to an alleged murder. Instead of taking the routine, objective, and necessary steps of investigating the McCabe's, Higgins, and the Alberts, Proctor, Buckenik, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation. What investigation? They didn't do one. Despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone from her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death, quote, could not be determined, end quote, and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, through the quote-unquote separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began the investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabe's and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike. But he did have injuries consistent with a fight and a dog attack. Proctor rejected her friend's belief that Brian Albert, the homeowner of the property where O'Keefe's body was found, would, quote-unquote, receive some shit, instead agreeing with another friend's assumption that, quote, you guys, meaning the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was, quote-unquote, going to put serious charges on Miss Reed, that she was fucked, and that there were, quote-unquote, zero chances she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Buckenik and other MSP troopers show Proctor had decided to focus suspicion on Miss Reed to the exclusion of everyone else. He told the troopers that Miss Reed was, quote-unquote, retarded, and that he was searching her phone for, quote-unquote, nudes. In the text chain, Sergeant Buckenik liked Proctor's text describing Miss Reed as retarded. Buckenik received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. That's such a weird sentence. Determining that his manner of death cannot be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred, and in his quest to charge Miss Reed, period. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him, quote-unquote, because either way Miss Reed was going to be charged. Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secure. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP Crime Lab requires proper processing of evidence at major crime scenes, including, quote-unquote, crime scene photography and evidence processing and recovery of latent fingerprint, footwear, tire track evidence. Neither the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts' home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where O'Keefe's body was found, until February 1, more than 3 full days later. No photographs were ever taken of the inside of the garage at 34th Fairview. This intentional departure from established protocols permitted Proctor and Buckenik to generate false incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, even though the MSP has at least 2 closer barracks, including Middleborough, the MSP headquarters for an accident reconstruction, and where the vehicle would ultimately reside for analysis. And Massachusetts was in the middle of an historic nor'easter. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP's facilities, and he knew he needed to have the evidence in close proximity to the crime scene at 34 Fairview. Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack but was intact, an observation ultimately testified to by Dighton officer Nicholas Barros, who was never interviewed by Proctor or any member of the MSP. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. That incident was captured on video. For nearly 2 years, however, Proctor memorialized the event as Miss Reed's Lexus, quote-unquote, coming close, but not hitting Mr. O'Keefe's Chevy Traverse. Proctor ultimately changed that narrative to admit the vehicles did come in contact with each other. Buckenik and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear tail light was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buckenik, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight, but notably no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as CPD access card swipe log obtained by a separate law enforcement agency, reveals seemingly unfettered access to the Sallyport by a myriad of individuals, including Brian Higgins, throughout the evening of January 29th, including just before and just after 5:30 p.m. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Buckenik worked together to obscure their role in manipulating the right rear taillight, and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buckenik to secure video footage from surveillance cameras located both inside and outside the Sallyport garage, which he did. These videos were manipulated in 2 significant ways. First, a critical 42-minute portion was deleted from the footage from the Sallyport, quote-unquote, front wall camera, the portion from 5:08:02 to 5:50:50, which included the exact time Miss Reed's Lexus arrived in the garage and the period Proctor was at the passenger side taillight. This footage would have shown that the taillight was intact. Second footage from the Sallyport back wall camera was inverted, which made the right side of Miss Reed's vehicle appear to be the left side, and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger taillight. The videos from inside and outside the Sallyport and Proctor's request for Buckenik to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buckenik presented one part of the video during his direct testimony under questioning by Assistant District Attorney Adam Lally. Buckenik narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed that he never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false, as in other words, he lied. He perjured himself. As he well knew, the video that Buckenik authenticated as fair and accurate was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right tail light for a significant period, but because it was inverted, it appeared in the video that he was behind the left tail light. They hoped this would allow Buckenik to lie about this issue at trial without detection. With this video and Buckenik's false testimony, the MSP, Proctor, and Buckenik attempted to mislead the jury in order to conceal the tampering with and planting of taillight material. Proctor and Buckenik took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. In warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, ring videos, Miss Reed's phone and Miss Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29th and had the vehicle towed to the CPD. Reports shared by the Dighton Police Department in 2023 revealed that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. And he tried to say that it was due to the time change, but if it was due to the time change, it would have been 4:30 because he said 5:30. It wouldn't be 4:17. It would be exactly an hour difference. What an idiot. Proctor maintained that the false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Miss Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buckenik drove them around in his car all day and then placed them in the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Buckenik, and many other MSP troopers. But I believe Proctor drove around with him in his trunk for like 3 weeks first, right? And then they laid him out at the Norfolk County District Attorney's Office to dry. They laid him on the floor on butcher paper, and they let him dry overnight, just laying out on the floor, and then he kept him in his car for 3 weeks before he turned him into evidence. In his trial testimony, Buckenik asserted that both he and Proctor were at the Norfolk DA's office drying out O'Keefe's clothing on butcher paper well into the evening, at least until 8:30 p.m. But in front of the MSP trial board in March 2025, Proctor testified that he arrived back home at 7 p.m. Furthermore, Proctor stated that he went from a debrief at CPD straight home and never mentioned visiting the NDAO with Buckenik and handling key items of evidence, despite Buckenik's claims that Proctor was handling the clothing that night. On these matters, Buckenik's and Proctor's sworn statements significantly differ and cannot both be true. Proctor and Buckenik also failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buckenik touched, manipulated, handled, or otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection, and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP Crime Lab. At some point before providing these clothes to the crime lab, Proctor and or Buckenik placed pieces of the SUV taillight on them, where they were then identified by the crime lab in 2023. Proctor also planted pieces of glass on the bumper of Miss Reed's SUV while it was in his possession at the CBD Sally Port garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall Bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. Those are the only 2 that matched, I think. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Proctor's, Buckenik's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buckenik nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Lochran, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during their investigation and only did so once Lochran was interviewed by a quote-unquote separate law enforcement agency and provided statements inconsistent with the MSP's narrative, 18 months after Miss Reed was already indicted and awaiting trial. Specifically, Mr. Lochran drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. You know, I've always wondered, what if they talked to Lucky Lochran and, 2 years after basically they arrested Karen Reed already, and he said that he saw that the Alberts dragging a body out to the lawn that night, but he was afraid to come forward. But since they were questioning him, he couldn't lie, so he had to tell the truth. What would they do then? Because this is 2 years later. Karen's already been arrested and indicted on murder charges. So it's like, what would they have done if that happened? That would be interesting, to say the least. Anyway, moving on. Sorry. Specifically, Mr. Lochran drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 and 3:30 a.m. He reported that there was nobody on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Lochran believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Mr. Lochran saw a Ford Edge in front of the Alberts' home that had not been there an hour before, despite a town-wide ban on street parking during the storm, but which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time, and so did Colin Albert. I think there were like 3 or 4 Alberts that drove a Ford Edge at that time. However, the Ford Edge was gone by the time Miss Reed arrived to the house around 6 a.m., and in its place she discovered Mr. O'Keefe's body. Proctor, Buckenik, and Tully never made any effort during the actual investigation to track down Mr. Lochran or any information relating to the Ford Edge. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28-29th. But Proctor omitted his name from his official summary of Miss Nagel's interview, and even though he listed all others who had been present at the house with Colin. When Miss Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorialization of the Julie Nagel interview mirrored almost exactly what was typed up in his police report, except for the words Colin Albert. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationships with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a CPD detective, instead of official channels when he coordinated interviews of witnesses, even though CPD was recused from the investigation. On January 30th, Kevin Albert texted Proctor on Proctor's personal cell phone to coordinate Proctor's use of CPD facilities to interview witnesses and about what witnesses Proctor planned to interview and when. Tellingly, despite the fact that he was investigating the murder of a law enforcement officer and that MSP rules and regulations require recorded witness and suspect interviews when possible, Proctor never used the recorded interview room at CPD and instead chose to keep the interviews offline. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both the MSP policies as well as various Massachusetts criminal statutes and further highlights the conflicted nature of MSP's investigation. I don't think it's so much a conflicted nature of MSP's investigation as it is they're just shitty cops. And they think they're above the law. Moreover, because of their close relationship, Proctor, Buckenik, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MSP and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to O'Keefe's death. These videos demonstrate that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Miss Reed. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos from the Sally Port to 30 days, therefore assuring the immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and withheld from the defense. Ms. Reed was arrested on February 1, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Ms. Reed was later rearrested on June 9, 2022, after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February 2023, her bail was reduced to $80,000 at the defense request. Now, my question is, does she have to pay $100,000 on top of the $50,000 she's already paid, or does she just have to pay another $50,000? I've always wondered that, and I've never asked. Miss Reed was tried twice by the Commonwealth. The first trial started in April 2024 and ended on July 1st after the court ordered a mistrial because of a hung jury. On June 18, 2025, following another nearly 2-month trial, Miss Reed was acquitted of all charges associated with the death of John O'Keefe, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January 2022, the defendant's actions have had profound effect on Miss Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be in prison for the rest of her natural life for a crime she did not commit. Ms. Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Ms. Reed has undergone tens of surgeries to manage her illnesses prior to January 29th and endured a blood transfusion just months before Mr. O'Keefe's death. In the aftermath of these charges, 2 arrests, and during both trials, Ms. Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Ms. Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. And mind you, she was paying for all these dozens and dozens of documented medical procedures out of pocket because she lost her health coverage when she lost her jobs. These pricks, they should have to pay for all of them. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Miss Reed has suffered at their hands. You're goddamn right. Excuse my language. The House defendants continued to execute on their strategy of misdirection and dishonesty for years after O'Keefe's death. For example, on April 10, 2023, 2 agents from a separate law enforcement agency made an unannounced visit to Jennifer McCabe at her home. She initially lied to these agents when she answered the door saying she was Nicole Albert. She then asked the agents to wait 10 minutes while she got ready. Afterwards, when asked by the agents, McCabe first told them she had called her husband, House defendant Matthew McCabe, and Carrie Roberts. But after the separate law enforcement agency agents warned her of the penalties for lying to federal officers, McCabe then revealed that she had also contacted John O'Keefe's mother and Norfolk District Attorney's Office and Brian Albert. McCabe made sure to warn other House defendants immediately, like Brian Albert and Matthew McCabe, that another agency was asking questions. The coordination between the House defendants and MSP, Proctor, Buckenik, and Tully was also not short-lived. For example, in the evening of September 25, 2023, McCabe visited Proctor's house. This visit by a key witness in a murder case to the home of the lead investigatory is not explained or even acknowledged or mentioned in any MSP report. In fact, Reed's criminal defense team only learned of McCabe's visit to Proctor's house when a photo of her Jeep was publicized. Furthermore, in 2024, on the eve of Miss Reed's first trial, Miss Reed's team learned that McCabe had visited CPD Sergeant Michael Lank, who was the ranking CPD officer on scene on January 29th, at his personal residence at 5:43 p.m. on January 30th and stayed until 6:28 p.m. It was only after Miss Reed's attorneys shared this data with the Commonwealth 2 weeks before McCabe's trial testimony that Tully met with members of the NDAO and McCabe to discuss her visit to Sergeant Lank's home. Neither Tully, Proctor, nor any other trooper memorialized this meeting or McCabe's visit to Lank's home. Furthermore, McCabe later testified on May 21, 24 that she went straight to Sergeant Lank's house from One Meadows on January 30th, but her cell data shows that too was false. McCabe's phone shows she stopped at 34 Fairview from 5:36 to 5:40. And even after this case was filed, some of the investigators have continued to coordinate and work with the House defendants. For example, in the fall of 2025, defendant Buckenik repeatedly fundraised for the House defendants on social media sites. He urged support for the House defendants against Miss Reed's, quote, evil, chaos, and lunacy, end quote. Proctor wrote more than 1/3 of the police reports in this case, testified at the state grand jury 3 separate times, interviewed every member of the Albert and McCabe families, and had possession, at least until March 14, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevy Traverse the day after Miss Reed was arraigned, had access to and reviewed all the ring videos, had access to and reviewed the surveillance from C.F. McCarthy's, had possession of all of the CPD Sally Port and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation while Miss Reed was forced to trial not once but twice. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7, 2024, mere days after the conclusion of Miss Reed's first trial. Proctor was terminated from the MSP on March 19, 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone, on October 18, 2025, Proctor officially withdrew his appeal with the Civil Service Commission. On September 23, 2024, an MSP internal affairs investigation found Yuri Buckenik failed to perform his supervisory duties in an ongoing investigation. On July 7, 2025, Buckenik was transferred out of the NDAO detective unit and reassigned to an administrative role in another division. Yeah, he was reassigned to a desk job. On October 18, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey, surprise, surprise, to continue detective work on the Reed case despite his demotion because of his behavior on this case. What Reed investigation? There is no more Reed investigation. It's over. Why is he still investigating her? Upon information and belief, MSP troopers David DeChico and Jeffrey Kutkowski were also disciplined for their misconduct associated with MSP's investigation of Miss Reed. Nearly every instance of such discipline in Proctor's unit occurred before this case was even fully adjudicated in the second trial. Proctor himself admitted to a trial board in March of 2025 that he informed his superiors Buckenik, Fanning, and Tully in February 2024, before the first trial, that he had testified before a berating U.S. attorney regarding the prejudicial messages on his phone and his relationship with the Alberts. Nevertheless, no member in Proctor's chain of command or in the MSP sought to discipline these individuals until after Miss Reed stood trial. 5. Counts. The preceding paragraphs are incorporated herein by reference. Proctor, Buckenik, and Tully violated Miss Reed's Fourth Amendment rights by engaging in a malicious prosecution of Miss Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Miss Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buckenik, and Tully caused Miss Reed to be seized without probable cause as described above, including but not limited to by leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Miss Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Miss Reed's unlawful treatment. Violating MSP's rules, policies, and procedures in all aspects of the investigation. Planting, fabricating, manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Failing to secure evidence in the crime scene, obtain evidence timely and appropriately, interview suspects, and investigate the Alberts, McCabe's, or Higgins, and allowing them to destroy potentially exculpatory evidence. Just 1 second, I need to get a drink. I apologize if I keep sniffling in the microphone. We live by tons of almond orchards, and it's almond season, and the almond blossoms are just killing me. Failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. Following her indictment by a grand jury, Miss Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. So I guess she did have to pay the whole $100,000. Well, it was reduced to $80,000, but still, it's not, $30,000 more on top of her $50,000. It's just a whole nother $80,000. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continued during Miss Reed's second trial, in part because of Proctor's false testimony at Miss Reed's first trial. Among other things, Proctor falsely testified that when he first saw the taillight on Miss Reed's car at Miss Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed on February 1, 2022, was in the same condition as on January 29th. He and Buckenik never touched any part of Miss Reed's vehicle when it was stored in the CPD salad port. He retrieved tail light pieces on subsequent searches at the Alberts home when he knew he had deposited or arranged for someone to deposit tail light pieces at the property. Chris and Julie Albert were his loose acquaintances rather than friends, and his statements in sworn affidavits, all claiming that the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were quote-unquote typos. Plus, remember, he misspelled all the witnesses' names. All of them. Not just one, not just two, all of them. That had to be intentional. There's no way it wasn't. Thus, Proctor, Buckenik, and Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 U.S.C. statute, costs, interest, and punitive damages. So, Jackson and Yannetti and Bob might get their legal fees after all, huh? The preceding paragraphs are incorporated herein by reference. A supervisor is liable under 42 U.S.C. 1983 when the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. Buckenik and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. They also knew or should have known that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidenced in his text messages, which were sent to Buckenik, among others. Buckenik and Tully could have taken easily available steps to avoid a constitutionally deficient malicious prosecution of Miss Reed. Those measures include, but are not limited to, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in O'Keefe's death, safeguarding the crime scene and the physical evidence, including O'Keefe's clothing and 47 pieces of taillight material and 19 pieces of glass from various sources to prevent anyone from planting, manufacturing, or manipulating evidence, initiating timely searches at the Alberts house, and quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, McCabe's, and Higgins, which would have prevented their later manipulation and destruction. By not taking any of those measures, Buckenik and Tully permitted Proctor and Tully permitted Buckenik to violate Miss Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Miss Reed's Fourth Amendment rights. In these ways and others, Buckenik's conduct constituted condemnation of or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitute condemnation of or acquiescence to Buckenik's and Proctor's behavior or gross negligence amounting to deliberate indifference. As a proximate result of these breaches, Miss Reed was wrongfully prosecuted for O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees, costs, interest, and punitive damages. The preceding paragraphs are incorporated herein by reference. Proctor, Buckenik, Tully, the Alberts, the McCabes, and Higgins shared a common design and acted in concert to frame Miss Reed for O'Keefe's death. As part of their concerted efforts, and among their many misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buckenik, and Tully would also act similarly by solely investigating Miss Reed. Proctor, Buckenik, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buckenik, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction and to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Buckenik, and Tully agreed to continue to handle the investigation even though they had personal relationships with suspects in the murder, which led to unlawful and unfavorable treatment of potential suspects. To continue to handle the investigation even though they had biases against investigating the House defendants because of the House defendants' ties to law enforcement. To continue to handle the investigation even though they had exhibited an extreme and personal negative bias towards Karen Reed. To violate rules, policies, and procedures in all aspects of the investigation, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury, to not secure evidence and the crime scene, to not investigate and obtain available evidence or timely and appropriately interview suspects, and to not investigate the Alberts, McCabe's, or Higgins. The McCabe's and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed and discarded. Finally, Proctor, Buckenik, and Tully coordinated the Alberts and McCabe's through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buckenik interviewed the McCabe's and Brian Albert in a cursory manner and all at the same location, midday on January 29th, and Nicole Albert on February 3rd. Proctor and Buckenik only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabe's. Proctor and Buckenik did not search the Alberts' phones or home where there was likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. As a result of the conspiracy between and among them, Proctor, Buckenik, and Tully never investigated the House defendants, and instead Miss Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Proctor, Buckenik, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor, Buckenik, and Tully were the state police employees investigating O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Buckenik, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. That is one fucking long sentence. How is that not considered a run-on? I'm almost certain if you wrote that in school, you would get points knocked off for a run-on sentence. As part of their conspiracy to direct law enforcement towards Miss Reed, at least some of the House defendants provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about Mr. O'Keefe's death and the investigation into it, and along with other House defendants took steps in furtherance of their scheme through each of Reed's criminal trials in 24 and 25. I don't know what that's a weird sentence. The proximate result of Miss Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars of legal expenses, and serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. The preceding paragraphs are incorporated herein by reference. Proctor, Buckenik, Tully, and the House defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws through threats, intimidation, or coercion. That's new. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as the dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor and Buckenik caused Miss Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Alberts' property where they would claim Miss Reed dropped off Mr. O'Keefe, the Alberts, the McCabe's, and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian, Albert, and Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Miss Reed's rights under the Fourth Amendment to the U.S. Constitution and Article 14 of the Massachusetts Declaration of Rights. As part of their attempts to direct law enforcement towards Reed, at least some of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about O'Keefe's death and the investigation into it, and, along with other House defendants, took steps in furtherance of their scheme through each of Reed's criminal trials in 24 and 25. Ms. Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. Moreover, the House defendants and Proctor's, Buckenik's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Ms. Reed to give up her defense and plead guilty to a crime she did not commit. Yeah, they were hoping she would strike a plea. As a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars in legal expenses, as well as serious emotional distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her costs, interest, and attorney's fees. The preceding paragraphs are incorporated herein by reference. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phone, ignoring exculpatory evidence such as O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buckenik, and Tully caused Miss Reed's indictment, arrest, and prosecution. Miss Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Buckenik, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. These criminal proceedings were instituted with malice as evidenced by Proctor's, Buckenik's, and Tully's knowledge that it was based on false evidence, Proctor's, Buckenik's, and Tully's bias and ill will towards Miss Reed, and for the improper purpose to protect Proctor's friends and acquaintances, the Alberts. The criminal proceedings terminated in Miss Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe would claim Miss Reed dropped off Mr. O'Keefe, Brian and Nicole Albert, the McCabes, and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones and eliminating exculpatory evidence. As part of their attempts to direct law enforcement towards Reed, at least some of the House defendants also provided false testimony at Reed's trials. House defendant Jennifer McCabe also lied to agents of a separate law enforcement agency when they interviewed her in 2023 about O'Keefe's death and the investigation into it, and, along with other House defendants, took steps in furtherance of their scheme through each of Reed's criminal trials in 24 and 25. As a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts and Higgins phone, Albert's home or the Alberts and Higgins phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buckenik, and Tully caused Miss Reed's indictment, arrest, and prosecution. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Miss Reed dropped him off, the Alberts and McCabes and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution of Miss Reed. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. As part of their attempts to direct law enforcement toward Reed, at least some of the House defendants provided false testimony. Just one second. At Reed's criminal trials. House defendant Jennifer McCabe also lied to agents. Okay, why do they keep repeating this? The defendants knew or should have known their conduct would cause Miss Reed emotional distress since it would lead to her prosecution for murder and other crimes, and the conduct did cause and is causing Miss Reed severe emotional and physical distress. The defendant's conduct perverted the justice system, allowed Mr. O'Keefe's true killer to escape liability, and threatened to imprison Miss Reed. It is the type of behavior that threatens civilized society and is therefore extreme and outrageous. As a proximate result of defendant's actions, Miss Reed suffered serious emotional and physical distress and injury. Okay, let's skip the repeats, shall we? As part of their concerted efforts and among their many misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buckenik, and Tully would also act similarly by solely investigating Miss Reed. Proctor, Buckenik, and Tully knew or should have known that the statements made to them by the House defendants were false and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buckenik, and Tully agreed with each other to use the House defendants' misrepresentations as a predicate for and implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. In furtherance, the conspiracy to fabricate, plant, and manipulate evidence purporting to show that Miss Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, they carried out multiple overt acts, including damaging the taillight on Miss Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th prior to the MSP CERT team's arrival on site. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Miss Reed's Lexus SUV sometime prior to the vehicle's processing by MSPCL on February 1. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and Higgins. The McCabes, the Alberts, and Higgins coordinated through text messages, phone calls, and on information and belief conversations, period. Higgins and Brian Albert coordinated through telephone calls and on information and belief texts on their phones, which were later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCabes, through his sister Courtney, who spoke frequently to Julie Albert. Acting pursuant to the plan, Proctor and Buckenik interviewed the McCabes and Brian Albert in a cursory manner the morning of January 29th and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the house. Proctor, Buckenik, and Tully also interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins' phone or search for communications between him and the Alberts and the McCabe's. Pursuant to the coordinated plan, Proctor, Buckenik, and Tully also did not search the Alberts' phones or home where there was likely evidence of O'Keefe's murder. Further, Brian, Albert, and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Following Mr. O'Keefe's death, among other acts, the McCabe's and Alberts agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Miss Reed's car. As part of this common plan, Brian, Albert, and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 29th for how long it takes a person to die in the cold. One or more of them then relocated Mr. O'Keefe's body and deposited it in front of the Alberts' house, where Jennifer McCabe claimed Miss Reed had dropped Mr. O'Keefe off earlier. The McCabe's and Alberts then coordinated what they would say to the police, all of them falsely telling investigators that Mr. O'Keefe never came into the house. At least some of the House defendants also provided false testimony at Reed's criminal trials. House defendant Jennifer McCabe also lied. Okay, then let's repeat. And had peculiar power, of course. Okay, that's all repeat. Proctor, Buckenik, and Tully's and the House defendants' conduct described herein were unlawful and tortious. Tortious? I don't know. Among other things, they constitute intentional infliction of emotional distress, negligence, common law malicious prosecution, and violations of Miss Reed's rights pursuant to the United States Constitution and the Massachusetts Declaration of Rights. As a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. Jury demand. Miss Reed respectfully requests a jury trial on all matters so triable. Wherefore, Miss Reed respectfully requests that the court grant her the following relief: enter judgment in her favor and against each relevant defendant on each count of this complaint, award her damages in an amount to be calculated at trial, along with pre- and post-judgment interest, costs, and expenses, award her reasonable attorney's fees incurred in connection with this litigation pursuant to 42 U.S.C. 1988 and any other applicable statute or law, and grant her such other relief as the court deems equitable and just. Respectfully submitted, Karen Reed, by her attorneys. Wow. So, that was quite the, sorry if I just rambled and went on, but it's like I didn't expect it to be that long. So, and had I known that, at the end it was going to keep repeating, I wouldn't have read each one. I thought, so I finally caught on. And then, of course, within one number, then it was a whole new, it wasn't repeating anymore, of course. So, there's that. All right. So, tomorrow I think I might, tomorrow I'll probably record a video about, Kelsey Fitzsimmons, motion or statement, submitted to the family court in regards to changes in the court's orders as far as the baby goes and whatnot. I don't think I'm going to do it live. I think I'm just going to record a video and post it. So keep your eyes open for that. And what else? I believe that's it. That was long enough, I think, right? So I hope it didn't just sound like a run-on. I was trying not to, interact too personally in between because I knew it was going to be a long video once I saw that it was 54 pages. And I didn't want to make it any longer for you guys. So that's why I didn't pause and interact and pause and interact. But yeah, it was way more detailed than it was last time, and she's asking for more, and she should. I mean, it is what it is, right? Don't poke the bull. Or as Turtle Boy says, don't poke the turtle. Anyway, I'm delirious. I thank you for watching and joining me, and I hope you enjoyed this video. Get out there in the sunshine while it's still sunny, because I think we in California, I think are supposed to get some more rain, if I heard correctly. But right now it's beautiful. It's like, wow, close to 80 degrees today, if not 80. Sunny, beautiful, clear skies. So yeah, in the meantime, stay safe, stay happy. I'm not going to say stay warm and dry because you don't need to right now. But yeah, stay safe, stay happy, and don't forget to like and subscribe, and I will see you guys real soon. All right? Thanks. Bye.